morning. Today's video, obtaining default judgment in small claims court for an unliquidated amount. Now, it's important to remember that these videos are not intended to be comprehensive, and it's important to refer to the small claims court rules before proceeding. What's the definition of an unliquidated amount? Well, it can be defined as a sum of money that has not been determined by the parties in advance and instead requires a court to determine the amount of damages. Under Rule 11, a default judgment for an unliquidated amount can be obtained prior to trial only if all of the defendants in the action have been noted in default. Why is this? We can't have a situation where a judge on a motion or at an assessment hearing determines one amount of damage and another judge, perhaps at a trial, comes to a different determination. Which of the two judges would be in the better position to determine the amount of damages? Well, in all likelihood, it will be the trial judge. Provided that all defendants have been noted in default, a plaintiff has two options for obtaining a default judgment for an unliquidated amount. The first option is by way of a motion in writing for an assessment of damages. This option requires completion of Form 15A, which is also known as a notice of motion and supporting affidavit. The second option for obtaining default judgment is by way of an assessment hearing. This option requires completion of Form 9B, the request to clerk, and perhaps an affidavit, which is Form 15B. What is required for a motion in writing for an assessment of damages? Well, first, we need an affidavit of service, which is Form 8A. Second, we need a request to clerk, Form 9B. And finally, third, we need a notice of motion and supporting affidavit, which is Form 15A. In a previous video entitled Obtaining Default Judgment for a Liquidated Sum, we examined the need for the affidavit of service and the request to clerk to note the defendants in default. As a result, we're not going to re-examine those two forms in this video. However, let's take a look at how to properly complete the notice of motion and supporting affidavit. Let's take a look at Form 15A. What we need to do is we fill in the title of proceedings. We always remember to attach our additional defendants page, which is Form 1A. And in this case, we're not going to fill in Part A, but instead we're going to scroll down to Part B, where it says this motion in writing for an assessment of damages is made by, and we're going to put in the name of our plaintiff, who asked the court for an order assessing damages against, and we're going to put in the names of the two defendants. Next, we need to put in the name of the individual who's going to be swearing or affirming the affidavit. Now, when filling in the pleadings portion of the affidavit, the first thing that you need to do is to state why the deponent is able to give the evidence. And what I've done here in paragraph number 1 is I've provided an example as to how that can be done. Now, once that's completed, it's my suggestion that you provide an outline of the history of the case, including the date that the plaintiff's claim was commenced, the date that the defendants were served, and the manner in which they were served, and also the date on which the defendants were noted in default. Now, it's important to remember that Rule 11 sub 5 of the Small Claims Court rules states that a plaintiff is not required to prove liability against a defendant noted in default, but is required to prove the amount of the claim. Nevertheless, it is good practice to very briefly include your reasons as to why the defendants are liable, in addition to supporting the amount of your claim. And finally, it's important to make the deputy judge's job as easy as possible. You need to be clear as to the terms of the judgment you are requesting. Here, for instance, is an example. And that's it. That is all it takes to complete Form 15A, which is the notice of motion and supporting affidavit. So what if you make a mistake in your motion materials? You're not going to be jumping off a bridge. What happens is the deputy judge reviewing your materials will either order that a supplemental affidavit be filed to address an issue or issues which he or she felt were not adequately addressed in the original affidavit, or alternatively, an assessment hearing will be ordered. Either way, the important thing is that you find out what the deputy judge believed was not adequately addressed so that it can be addressed either in your supplemental affidavit or it can be addressed prior to the assessment hearing. But let's take a look at the real elephant that's in the room. What happened to the coffee mug that was here? Why are there now scales of justice? Let's take a look at the plaintiff's second option, that of an assessment hearing. What is required? The first thing that's required is completion of a request to clerk. When completing this form, we're going to request two things. We're going to request that the clerk note the defendant, or if there's more than one defendant, that all the defendants be noted in default for failing to file a defense within the prescribed time. And second, we're going to request that the clerk schedule an assessment hearing. Either at the time we file the request to clerk or on a later date, the court will issue something called a notice of assessment hearing, which will contain the date, the time, and the location of the hearing. It's important to remember that an assessment hearing is to proceed in much the same manner as a trial would proceed under Rule 17, albeit without the participation of the defendant or defendants. So what does this mean? Well, what it means is that we're going to need some evidence to support our claim for damages. That evidence can be by way of an affidavit or by way of viva voce evidence from a proper witness. If a plaintiff intends to rely on an affidavit, then Form 15B must be completed, and that form will be completed in pretty much the same manner that the supporting affidavit in Form 15A was completed. It's preferable that the affidavit be filed in advance of the assessment date so that the judge can review it prior to the assessment hearing taking place. However, if it's not possible to file it in advance of the hearing, no problem. It can always be filed at the hearing itself. Now, at the hearing, the deputy judge will review the affidavit and make a judgment accordingly, provided that the affidavit is satisfactory, and further provided that either the plaintiff is in attendance, or if not, at least the plaintiff's paralegal or lawyer is in attendance, then a judgment will be granted. Now, one doesn't need to rely on an affidavit for evidence. One can rely on the viva voce evidence of a witness, perhaps the plaintiff or perhaps just a proper witness. Now, in this regard, a paralegal or a lawyer representing a plaintiff is not a proper witness. Items such as photographs, invoices, proof of payment, etc. will have to be entered as evidence through this particular witness. Now, which is better? Is it better to proceed by way of an assessment in writing or by way of an assessment hearing? Well, that's a matter of personal preference. My personal preference is to proceed by way of an assessment hearing. That way, if the presiding deputy judge has any questions or concerns, I can address those questions and concerns immediately. One thing to remember is that the documents that we've been speaking about can be filed electronically, provided that the plaintiff's claim was issued electronically. However, documents that are filed electronically are to be filed in paper form with the court within 14 days. So with that, we are all done, and I will see you next week. Have a good week.